the chat group itself, we can also share events with you, share what's going on with you, and also what's happening with Ariba, what's happening with what's going on that in the coming days. We can give you the updates, and then we can also chat and connect with one another. If there's a synergy, to really forge maybe collaboration. Yeah, this is the way to do it in the chat group. So I really encourage you guys, please join our chat group, okay, so that you can be in the loop. You can get all the information and can connect with one another. Okay, so housekeeping rules: keep your mic on mute, okay, throughout this presentation. If you have any questions at all, please feel free to use the group chat. We have co-hosts that will be actually looking at the messages, and then they'll be posting some quick answers to queries you may have as well. Okay, keep your videos on. We encourage you to keep your videos on unless you need to be away from your desk, okay? Video is actually also to really appreciate those speakers so that they can see you and they are able to interact with you face to face. Okay, now right at the bottom right of the screen, there's one button called reaction. So in the reaction button, you can actually applause, okay, or you can give a thumbs up. Now these things where we can engage the speakers. So if the speaker says something that resonates with you, I'll encourage you to, basically connect with them and say, hey, great, thumbs up. That also gives them the encouragement that they are actually on the right track and giving you the value, okay, that you are seeking. So I encourage you to use those. Post your questions on the webinar chat for the Q&A. And basically, one of the things I also encourage you to do is to list not only your name, but your company. So if you look at each of your individual profile, you can actually right click. If you put your mouse over there, you can see these three little dots, okay? If you click on the three little dots, you can actually use this option called rename and put your name followed by your company. So if you do that, then it's easier for people to identify who they're speaking with, and also what company you're from, so they can actually ask you about your company as well. And I really encourage everyone, okay, to after the presentation, after the Q&A, do find time to stay back and join us for the breakout room sessions, because it's one of those events where you actually get to talk with one another and share. And it's really, really great. It's really, really good when you are able to do that, and connect with one another instead of just a static webinar. Okay, so basically what I'm going to do is I'm going to, for those who are new, okay, I'm going to really give a quick intro, okay, what this is all about. The Emerge Stronger webinar series is a collaboration between Brands for Good Asia and ASEAN CSR Network. This webinar series started in May this year to help and strengthen entrepreneurs, businesses, and organizations to connect, collaborate, and encourage one another through these challenging times. Over the past few months, we have thousands of people in Singapore and around the region who have attended one of our webinars. People who have logged in from China, from Indonesia, Malaysia, Cambodia, the Philippines, and even Australia. To give you a deeper insight to the work we are doing, okay, it gives me great pleasure to invite the co-founder and also the co-chair of Brands for Good Asia, Mr. Alan Ng, to say a few words. Alan, over to you.
Thank you, Vincent. Let me share my screen. Okay, you all can see my slides. Thank you all. Okay. Thank you once again. Thanks, Vincent. Good afternoon, everyone. For those of you who have heard this presentation before, please bear with me. But for those who are hearing this for the first time, well, this presentation is for you. Yeah. Wait, how do I? Okay. Okay, firstly, I want to thank many of those who supported and helped make Brands for Good what it is today, right? Our organizers, our sponsors, our partners. So I shall not dwell too much, but I particularly want to thank Maybank and 01 for being our sponsors, and they will be sharing a little bit later as well, right? And also our supporting organizations, right? Here also we want to thank our judges for the award, and also individuals And I believe what brought us together is a simple shared belief that brands for good can change the world for the better. Right? The vision of brands for good can be encapsulated in one word: purposeful. The branding expert says, don't just build a business, build a brand. But we at Brands for Good here says, don't just build a brand, but build a purposeful brand. Right? The Brands for Good companies believe in triple bottom line objective: people, planet, and profits. We pay attention to the world around us. And when we recognize a need in our community or society as a whole, we seek out ways to tackle that need with a business model while turning in a profit. Right? So in 2018 and 2019, Brands for Good Award publicly recognized 67 such exemplary companies. Right? We have published 2 booklets containing their stories and the creative way that they've done their business model. All right? And we have also made 3 videos that has already been uploaded on YouTube. We also have a LinkedIn page. We hope that you can come and support us there. Right? And for this year, right, we will be partnering with ASEAN CSR Network to organize the ASEAN CSR Conference. Invention Convention Global has decided to move their 2020 event in Singapore to 2021 because of COVID-19, right? And Brands for Good is their co-organizer. So we are looking for companies with a creative approach to achieving their triple bottom line. We want to help such companies gain publicity and boost their branding. So do you have a clever business model or technology or product or design or the way you provide capital and leadership? We want you, right? We are now open for nomination. So please connect with us via this link at the top. This December, together with ASEAN CSR Network, we will run the first ASEAN CSR Conference and the Brands for Good Award virtually, our first attempt, and hopefully it will make history. So do note the date, 10th of December. So why join Brands for Good? All right, let me conclude with 3 take-home points. Number 1, join us and our partners to make the world a better place. But let's start with Asia. It is, if not for ourselves, surely for our next generation. All right, let's make a mark, leave a legacy, inspire our kids. All right, number 2, use your business to make that impact. Make it a force for good. Pursue the triple bottom line. And that's why we organize webinars like this to learn from experts and get new ideas. All right, and finally, you don't have to be alone. Let's build a community. Let's build this community together. Let's champion together. Let's inspire every business to become a purposeful brand. Thank you. So now I'll pass the time over to Alan Hong, right, from Maybank. Anyway, here are some more pictures of the networking events that we did. Yeah. Okay, thank you.
Development head for Maybank. Oh, sorry, was I muted? Give me a minute.
Yeah, now we can hear you.
All right. Yeah, I was saying, thank you everyone for the time. This is, I think, a sponsor's privilege to have some time to sell Maybank's Koyo. So bear with me, I don't have many slides. My name is Alan from Maybank SME. I'm the business development head for the SME banking department. So today I'm here to share what Maybank can do to support businesses in times of crisis. All right. So a brief introduction to see Maybank Singapore is one of the group's home markets and largest overseas operation. Why I say this because actually Maybank Singapore is locally incorporated. So we are a different entity from Maybank Malayan Banking Berhad. Also, we are the group's overseas operation, which is one of the main contributors, with assets of 76.5 billion as of 31st December and growing with Singapore since 1960. So in fact, this is our 60th year in Singapore. By right, we should be having a lot of party this year, but so sad with all the social distancing and the economic environment right now. So it's rather muted this year, right? So let's hope for the better since we are right now in phase 2. So hopefully things will get better. We are also a qualifying full bank with more than 27 service locations and one of the 7 DSIBs, domestic systematically important banks in Singapore. A mouthful. So what it means basically is you can consider as one of the local banks besides the 3 local banks in Singapore. So if you exclude the 3 local boys, we are like the 4th local bank, some would say, or with 27 service locations, or with all the banking services the bank can offer. And I believe this year is the 3rd year that we are partnering with Brands for Good. Basically because I think we still feel a certain kind of synergy with Brands for Good. Our mission is to humanize financial services, quite in line with what Alan has shared just now. I recall the first P was people, right? People, planet, and profit. So I think this is why we have been supporting Brands for Good for these 3 years. So this is what we are doing right now to help the local businesses to so-called tide through this period. I guess most of you are not foreign to all these schemes that the banks in Singapore are offering. Things like the enhanced working capital loan, temporary bridging loan to help with your cash flow, EFS trade loan insurance scheme, and loan payment deferment. I wouldn't go through in detail each of the categories, maybe just a brief overview. All right, since I guess by now everybody is very familiar. I think most of the banks have already contacted you once or twice. Right, so I just briefly go through. The enhanced working capital loan has been around for quite some time already. I think it's a staple support from the government for SMEs. So for this one, it's a financing up to 1 million, no collateral required, and a deferment for 1 year, which is the opt-in basis. You can choose not to, of course. So I just clarified for this no collateral required. I guess there's a lot of SME owners keep asking the bank, no collateral, do I have to give guarantees? Sorry, the answer is yes. The business owner still must provide the personal guarantee for these loans as a commitment for taking up such loans, right? So if you have further questions, you can ask me later. Then the other one is the temporary bridging loan program. This is a very special term loan for specifically to tide businesses through this very difficult period. So the financing up to 5 million. 5 million is for medium enterprises. Then small enterprises can get up to 2 million. How we differentiate is we look at the turnover. If your turnover is 20 million and below, we classify you as a small enterprise. If you are exceeding 20 million, you are considered as a medium enterprise. Okay. Same type of what is this? A deferment of principal repayment. Same thing, no collateral required. So for this, these 2 loans is basically the bank gives you cash to you can use it for whatever purpose that you want. But just to share, typically such loans we deem this as what do you call more of a long-term financing, because when you take up such loans, you have to go through a tenure of maybe 2 to 5 years, or to slowly pay back the bank. So when you use such loans, maybe you can consider it for more of a long-term type of investment, like maybe shifting a business online or upgrading certain things, R&D, with a longer period of time frame. Not just to purchase stocks or to help with our purchases. For purchases, we have another product to assist you, which is the EFS trade loan and the loan insurance scheme. These 2 essentially is the same. It's more of a subsidized trade facility for SMEs. So what happens is when you apply for this scheme, the first level you go through the loan insurance scheme, right? Then this will be underwritten by insurers. right? If your company qualifies, then you'll be under this loan insurance scheme for trade financing. And the premium subsidy is at 80% right now, subsidized by the government. I think it's about 0.5% or so. If the underwriters did not approve your application, then you go to this EFS trade loan, whereby EFS will underwrite the whatever amount that's not approved. So meaning to say, more likely than not is your trade application will be approved. Okay, maximum amount for this EFS is at 10 million. And what else? Okay, maybe I just briefly touch on the main product that we are selling. Basically, inventory stock financing, the purchase link. This is what we are focusing on to help the businesses in Singapore. So in layman terms, it means that when you make a purchase, the bank will help you pay the supplier. Then you, the business, will pay the bank back. So instead of using your own cash, you get the bank to make a payment for you. Then the bank gives you a credit term. So very simple, very layman, right? And the last support that we have is for existing loan payment deferment. So for property loans, you can defer principal plus interest payments until 31st December 2020, right? Then this period, after we will extend the tenure for whatever period that you have deferred for. So if you defer for 6 months, after it ends, you will get a loan, the tenure extension for another 6 months. Basically, it's like a timeout, right? And for hire purchase, we have the same thing, payment deferment P plus I for up to 6 months. This one, I advise don't anyhow or don't just go for it because it's available, because you know cars in Singapore are basically a liability, depreciating every year. So unless you really need it, then you try to go for this deferment. And the last one is trade finance. We also have some sort of payment relief. So for businesses who have their funds somehow stuck after you have used our trade finance, you can go for extension up to 90 days. So P plus I deferment if extension is less than 90 days. So maybe the bank has given you 90 days credit terms for your trade line. If you cannot make it in time, you can extend another 90 days, up to 180 days. I hope that's clear. So requirement-wise, basically we are helping companies who are registered and operating in Singapore, and at least 30% local equity held directly or indirectly by Singaporeans or Singapore PRs. That means we are really here to help the local people. If you are 100% foreign owned, then you won't qualify for all these schemes. Right. The group revenue of up to 100 million or maximum employment of 200 employees. So basically, this is some control to really help the smaller guys to tide through this period. One more thing to note, all this enhanced working capital loan, TBL, is up to 31st March 2021. So if you have not applied for all these loans, you still have some time to consider and think through whether you require the extra funding. Okay. So that's the end of what we have to offer. If you would like to find out more, you can go to this maybank.sg/COVID-19 relief package. You can submit your application online. All right. Thank you very much. That's the end of my part. I will pass it on to Evelyn from 01. Evelyn?
Thank you, Alan.
Evelyn, we have to keep it tight. Sorry, just be mindful of our timing.
Sure.
Thank you.
Okay. Can everybody see my slide?
Yes.
Okay. Hi, everybody. I think some of you would have seen this presentation many times.
Sorry,
So
Evelyn, we're looking at your speaker notes.
I don't have, but I'm looking at the full screen name.
Never mind.
Okay, never mind.
Hey, sorry, you can run now. We're looking at your video now.
Is it a video?
Yes.
Yes.
Yeah, that's we're 01. We were founded by Stewart, our CEO. He's not here today. I think he's in another meeting. So we were founded in year 2017 together with 4 other corporate partners. And we went live in 2018. And to date, we have about over 70,000 signups. I mean, something in relation to Brands for Good, we do have our own CSR program, which we tie up with the East Coast. This project called Give a Line, Change a Life, whereby we sponsored all the inmates who are newly coming out from the prisons. We sponsored them a Nokia handphone, as well a 01 unlimited subscription plan for 6 months, to help them for the first 6 months of their, their life out of the prison. That is still ongoing, and whoever is interested in this program, you want to do some kind of CSR, you can also contact us for this program. Okay, for those who know that we have previously, we have 2 very basic packages. You may be excited to know that we have enhanced our 1 GB plan to 6 GB plan right now at the same price of $9.90. All right, so all of you, I think Glenn and Alan, you are on this plan, 1 GB, be patient. We will be upgrading all our existing customers to our 6U plan. Okay, something exciting. And for Brands for Good partners, we are also giving a free trial for all corporate. You can email to us at cis@01.sg, and we can chat with us about our corporate 30 days free trial. Okay, if you need to contact us, you can contact Stewart and myself. Our details is in the slide. You can take a picture of it. And that's about it. Fast and sweet.
Thank you very much, Eileen. That was
Thank you.
really compressed presentation. Thank you so much for respecting your time. Okay, it's now is a good time to really basically put yourself on video, because what we're going to do, we are going to take a group photo. Okay, so can I get everyone that is currently online and to basically
you can stop sharing.
Yep.
Okay.
I can't get to the button.
The top of your screen, middle.
I know, I can't get it.
I got it for you.
All right, thank you.
Wonderful.
Why? Very good, y'all.
Okay, all right. So now what we're going to do, okay, we're going to put on our best looking faces, okay, for this group photo, okay? It is an exciting time. Check, I want you to get ready. Guys, if I could get you, okay, all to basically put yourself on video, okay? You got about 30 seconds to comb your hair really quick, if you haven't done so. Put yourself on video, because what we're going to do is we're going to take a group photo, then we're going to share it in the WhatsApp group later on. Okay, so if you haven't signed up to the WhatsApp group, please sign up so you can get a group photo of your best looking self. If you look at a group chat, okay, you can see all the links to the WhatsApp group, okay, so you can join, okay, at any time. Now would be the best. Okay, so let me see, Shaq, can you see us and basically let us know when we're ready to go,
Sure.
when you're ready to take the photo?
Yeah, we're ready in 1, 2,
Oh,
3.
wait, hang on. Everyone, can I get you to put up your thumbs up?
Okay, yeah.
Thumbs up, just do the thumbs up, okay? I think it's gonna be pretty cool, all right? Thumbs up. Okay, so Shaq, do the countdown. Okay.
1, 2, 3. Then the next set, 1 second. 1, 2, 3. And the next one, 1, 2, 3. Thank you so much, everyone.
Thank you very much. All right, now we've got everyone looking at their finest, and it's also an exciting time because it's almost time to introduce the guest speakers. Okay, now today, okay, now this is something I don't want to get wrong. Okay, so I'm going to have to read from here. Okay, Today we got two very special guest speakers. Okay, one of them is Weiyi Tan. Okay, Weiyi is a partner. Okay, both of them are from the Harry Elias group. Okay, Weiyi is a partner in the litigation practice group and specializes in cross-border dispute and corporate investigations. She represents clients in a range of commercial dispute and advises clients in investigation and enforcement actions focused on corruption, financial fraud, and other white-collar criminal offenses. Okay, so what she's going to be sharing with us today will be on the recent developments in the areas of corporate compliance and investigations, okay, which is really exciting. Now we got the second guest speaker, Farah Isaac. Okay, Farah is a senior associate at Harris Elias Partnership, and she specializes in commercial dispute. Okay, she's experienced in litigation, arbitration, and mediation. Okay, so we've got these two lovely ladies that's going to be sharing with us. Okay, Farah will be sharing points from the recently enacted COVID-19 temporary provisions act, which is a piece of sorry, someone is speaking. Sorry. Okay, so Farah will be sharing points from the recently enacted COVID-19 Temporary Provision Act, which is a piece of unprecedented legislation passed by Parliament that has a direct impact on contractual obligations and dispute in Singapore. So this is another interesting subject, which I think many of us are here to listen and to really learn. So, I want you guys to, virtually put your hands together. Okay, I'll get Weiyi to start off and to really introduce us to the topic today. Okay, Weiyi.
Hi, thank you, Vincent, and good afternoon, everyone. Thank you for participating in today's webinar. Vincent has summarized the topics that Farah and I are going to talk about. And, I know a lot of people, when I say I specialize in disputes, and court matters, they generally are not very keen to talk to me. I mean, no one wants to be involved in a dispute, and it's something that you want to stay away from. You only speak to a dispute lawyer when you have no choice. But today, what we're going to do is we'll focus on recent updates arising from the COVID-19 crisis, which all of us are going through at the moment. Farah is going to give you an update on the legislation that is passed, and it is really to help address the challenges that businesses face during this time. And I will be talking about some of the trends that we've seen in the recent months, the types of disputes that we have been asked to advise on, and the issues that have arisen. And in the course of talking through those examples, I hope to give you some tips on how to deal with these issues if you have to deal with them, and also how to prevent some of these disputes from arising. So with that, I will hand over to Farah to talk about the recent legislation.
Thanks very much, Weiyi. Hi, everyone. Let me just bear with me while I get my slides up on the screen. Let me see. Okay, I hope everyone can see my slides. So, yeah, all good? Okay. So, thank you very much, Weiyi, for the introduction. As she mentioned, we're living in an unprecedented time right now with COVID-19. This is not something I think that anyone could have anticipated, the extent to which it has affected all our lives. Even with the SARS crisis, which extended to closure of schools and people staying home voluntarily, it was nothing like this. And it had not affected businesses in the same way as this. So inevitably, COVID-19 has not just caused us to have to stay home under lockdown, not being able to see our family and friends as much as we would like. It has also had a significant and dire impact in some cases on business and on contracts. Contracts, of course, effectively the lifeblood of commerce and the economy. They are what make the world go round. And as a result, there have been some serious implications as a result, which legislation has stepped in to address. So I'm going to talk about the impact of COVID-19 on contracts, and particularly on the legislation that has been put in place to address this. Okay. Right. So it's created unprecedented disruption. And the simple fact is many contracts have become completely impractical, or even in some cases impossible to perform. And the thing is, when you have parties that don't perform their contracts, usually it's someone's fault. Someone has refused to make payment or been unable.
Hey, so this matter, the client is Larry Jewelry.
Yep.
And
hello?
Sorry, Farah, please continue. I think Weiyi was online just now.
Okay, no problem. Everyone can hear me fine?
Yes,
Yes,
yes.
you can.
Okay, good. All right, so as I was saying, yes, of course, we all have these contract parties who refuse to make payment, or just through perhaps inability or some kind of problems, they are unable to supply the goods. This happens all the time. But now we are in a case where so many contract parties, because of COVID-19, have just been unable to comply with their contracts. Money is not coming in, business is not coming in, shops are closed. It has just become an impossible situation. And the fact is that, especially in my experience now as a lawyer, I have seen that many contracts do not provide for this. Even contracts that you would have thought actually did have a provision. So it's very common, I'm sure many of you may know, you may have heard this recently, force majeure clauses, right? So you may ask, Farah, force majeure clauses, aren't they exactly for a situation like this, which is an unprecedented global pandemic? And surprisingly, I can tell you no. This is something that even in some cases, a force majeure may not even address. So for example, I'm just going to run through quickly for those of you who may not be familiar, what are usual contractual remedies, contractual reliefs are for a contract that cannot be performed in a normal circumstance. Usually we have force majeure and we have what we call frustration, which is exactly what it sounds like. Parties are frustrated because their contract cannot be performed due to something that's beyond their control. Now, a force majeure clause may say, for example, if something happens beyond the party's control, if there's an act of God, if there is some kind of natural disaster and the parties cannot perform, then it will say, oh, then the parties don't have to pay, or then they can pause the contract until it's safe to continue. Now, the thing is, a force majeure clause, whether it will cover your contract for COVID-19 or not, depends on the exact way that your clause is drafted. And there are as many ways, I would say, to draft a force majeure clause as there are lawyers. So even if your contract refers to pandemic or act of God, maybe it will resolve your problem with your contract party, or maybe it will not. It's impossible to say, except for looking at your specific contract on a case-by-case basis. It's all a question of interpretation. And even if it's provided for, so let's say I have a very common issue, which is I have a lease contract. And lease contracts are one of those most common contracts that contain a very wide force majeure clause, right? It may say that in the event of pandemic, act of God, etc., this lease will come to an end. But now when I zoom in on the lease contract, it will actually say the lease contract force majeure clause, this contract will come to an end when the premises are unusable for 30 days. Then the parties have an option to terminate. Now, how does that help me if, because of government lockdown, my premises is perfectly fine, but I cannot open it, and therefore I cannot have customers and I cannot pay my rent? It just doesn't help. And on the other hand, if there's no force majeure clause, we have something we call a frustrated contract, which is that because something has happened through no fault of either party, because of unforeseen events, this results in the contract being completely different from how they expected, how they contemplated. It cannot be performed. But this doesn't always help me. What happens if I cannot perform some of my contractual obligations because of COVID, but maybe I can perform others? It's hard to say that that's a frustrated contract. Now, parties can always negotiate, right, when there are these issues. Of course, in an ideal world, we can all go to our contract parties and say, hey, because of lockdown, because of COVID, I can't do this right now. How are we going to fix it? But the truth is, when parties are under pressure, when they're fighting for the survival of their business, or when there's a drastic difference in bargaining power, it is simply not always possible. So the government has recognized that they need to step in, and they have enacted this very powerful piece of legislation to help business and help parties through this crisis. This is the COVID-19 Temporary Measures Act. This is a groundbreaking piece of new legislation that has been put in place, and its purpose is to help us to navigate these very challenging times ahead of us. So this is an act that provides for temporary relief. For now, it's an initial period of 6 months from 20th April, but it can be extended depending on how the crisis plays out. Just in a very short summary, what does this act do? It helps certain parties, certain contracts, parties to certain types of contracts to claim some kind of relief, and it prevents certain contract parties from suing each other, taking legal action against each other. And it provides what we call an assessment regime. So if the parties have a dispute about where the relief lies, they can go to the assessor. I'm going to explain more about this in detail, of course. But the key points to note are that only very certain types of contracts are actually covered. Only contracts entered before 25th March 2020, before we all understood how drastic this COVID situation would be, only those are covered. And only contractual obligations performed on or after 1st February 2020 are covered. For example, your payment of rent in January is not covered, but your payment of rent in February is covered. That's one example. So now you might ask me, only specific contracts are covered. What type of contracts? So not every contract gets effectively this temporary get out of jail free card that the COVID temporary measures provides. And bear in mind that this get out of jail free is not forever. It is just a temporary solution to take some pressure off. It does not make your problems disappear, of course. So what kind of contracts? Generally, these are contracts that involve kinds of loans, types of mortgages, some leases, tenancies, and licenses, and contracts that involve certain type of immovable properties, so houses, commercial buildings rather, and commercial units. Fixed assets, machinery, your power plant, your factory plant, and your factory machinery, for example.
You want to flip your screen, Farah?
I hope I can figure out how. Let me see. Yes. Okay. Yes, thank you. Thanks for that. Okay. So what type of contracts are affected? Now I'm just going to run through the types of contracts. Not everything is on this slide here, so I'm going to explain to you all the types of contracts that are actually provided in the legislation. So primarily, loans from banks or finance companies which are secured against commercial or industrial property located in Singapore. So if you have a mortgage which is secured by a commercial property, purchase of a commercial property secured by a mortgage rather, that would be covered. Or if it's secured against any plant, machinery, fixed assets which are used for business purposes, manufacturing, production. These specific kinds will be covered. Next, hire purchase or conditional sales agreement for commercial vehicles, or for plant, machinery, or other assets used for business purposes. So really business equipment hire purchase is covered. Now, construction contracts, I'm sure you've all seen, the cranes and the construction sites are all on pause or very, very slowly getting back to work. Construction contracts or supply contracts are covered, and any performance bond for such a contract is also covered. Now, this is a very important one. Next, lease or license of non-residential property. So unfortunately, any of you who have issues with your landlord for your private home, your private residential property, maybe having difficulty paying rent, you can still talk to your landlord to try and get some help, but you're not going to be covered by this act. Even if you use your residential property for business, or rather if you rent a residential property and use it for business, you will also not be covered because only non-residential properties are covered. Just a quick one, you might want to ask me, what is a license? What's the difference? So a lease, of course, is what most of you enter into when you have your business premises. A license is just a permission to occupy a property, which is mainly for co-working spaces and service offices. So where you don't have exclusive possession of the place. So that's a license. Those are also covered. Of course, events, weddings, tourism-related contracts, and concerts, those are all covered because we're not having any of those right now, or at least on a very small scale. Now, option to purchase. So if you've gone to a housing developer and entered an option to purchase or a sale and purchase agreement, that is also covered. And a relatively new, 20th of June, they've added this, lease of plants, machinery, or fixed assets used for business purpose, or commercial vehicles are also covered. Unfortunately, this commercial vehicle does not extend to taxi or private hire cars. So for Grab drivers, unfortunately, this relief won't apply to you. But ultimately, what I would say is that parties can still try and negotiate, try to reach solutions with their contract parties. But those who are actually covered, their contracts are covered by this act, will have an additional layer of government-mandated temporary protection. Oops. Okay, what is the relief that I've been talking about? Now, as I said, this does not magic away your obligations and your problems, but it gives you breathing space. So it's a temporary pause on enforcing obligations, initially for a 6-month period from April 2020. It may be extended. Now, during this pause period, your contract party cannot do what we call is enforcement against you. So they cannot sue you for breach of contract. They cannot evict you from your non-residential property. They cannot sue you. Your landlord cannot terminate your non-residential lease or repossess or forfeit or re-enter your property. Your creditors cannot sue you or make your business bankrupt. So they cannot bankrupt you or make your business subject of a winding up petition. And they cannot take your property if you used it to secure a loan. So as you recall, I mentioned that loans secured by property are covered. They cannot repossess your property. But remember that your obligations under these contracts do not disappear. Unpaid rent, fees, interest will continue to accumulate. So you will have to pay it off eventually. And there are additional reliefs for construction and event and travel related contracts. For example, no damages for delay, refunds of deposits, no cancellation fees. But parties must serve what we call a notification for relief to receive this relief. So I'm just going to talk about this on the next slide. But very quickly, I just want to say that the Act also provides some famously talked about, I would say, provisions that are beyond the scope of this talk, but they're important to businesses as well. So I'm just going to quickly mention. The Act also provides arrangement for remote meetings, the remission of property tax, so landlords having to pass on property tax remission to their tenants, and of course rental waiver, limited rental waiver for affected tenants, and the control orders, which is the lockdown that we all faced recently. These are also provided to some extent by the Act. Okay. Now I'm just going to run through how to get this relief. So it's not automatic. You cannot sit back and assume that you're protected. You need to take active steps to protect your business if your business is in trouble and you need help. So if your contract is covered, it's one of the contracts that I mentioned, and you, a party to the contract, is unable to perform, and this must be mainly as a result of COVID-19, and these are things that you had to do after 1st of February 2020. Then a party who is asking for relief can serve a notification for relief. This can be found on the Ministry of Law website, details on how to serve. The website has very helpful information as well on this. You have to serve this on your other contract party or parties. And if you do not serve a notice, yes, you can still enter into settlements. You can still, that will bind you. You can still have a judgment against you. You can still have enforcement against you. So it's really in your interest, if you're in trouble, to ask for relief. If you do qualify for the relief and you serve the notification, then the other party cannot sue you. They cannot commence arbitration proceedings against you. And if there are pending proceedings, you will be able to take steps to pause or dismiss those proceedings. For that, it's best to get specific advice for your situation. But you cannot just leave it and hope that it will go away automatically. It will not if you have existing legal proceedings against you. So just bear that in mind. So the notification will activate the relief and stop other parties from taking these prohibited actions against you if they haven't already. And these actions, like I said, include enforcing the security, taking away your security, enforcing judgments, eviction, terminating lease, lawsuits, and bankruptcy proceedings. If you have any dispute with your contract party about this relief, it will be determined by an assessor. Just want to go through quickly because I'm running out of time. Who are the assessors? These are civil servants. They are protected from liability for their decisions. So they can't be sued for the decisions they make. And effectively, if a party feels that it's unfair for someone to claim relief, for example, you're claiming that you cannot pay your rent, but actually you're a massive company that has in fact done well under COVID-19, then they might want to apply to an assessor to say that, look, I'm having a lot of problems. I feel that this is unfair. Can we have an assessment? Or they are experiencing serious hardship. For example, your landlord who doesn't receive your rent is in trouble as a result. Then they will go to the assessor. So what does the assessor do? Effectively, they are there to provide, most of all, a just and fair, equitable outcome to any disputes. And they may consider your financial situation if you are asking for relief, whether you can perform the contract, whether you're actually in a good financial position, even though you're asking for relief. They may require you to still pay a sum under your contract if they feel that you can do so and that your other party is having undue hardship. Or they may reverse a repossession of goods or forfeiture of property. So if your landlord has taken away your property in breach of the act, they may reverse it. They may order return of deposit, for example, for event contracts, or order forfeiture of your deposits. And they have a pretty wide discretion to make decisions to get a fair outcome, because ultimately that is what they're there for. And their decisions are binding with no appeal. You cannot claim legal costs. You cannot have your lawyer to represent you in the assessment proceedings. So I hope that was a very useful rundown for you, just a primer on the basics of the Temporary Measures Act. And I will be happy to answer your questions after the presentation. Thank you.
Thank you, Farah. Weiyi?
Thank you, Farah. Let me share my slides. Okay. All right. So before I begin, I saw a question from Lillian in relation to the COVID-19 Temporary Measures Act. And The question is whether the notification for relief can be done over email. The notification for relief is to be filed using your court pass if it is on behalf of a company, or the Sing pass if it's an individual claim that you're trying to make. So if you need more information, you can get it from the Ministry of Law's website, or feel free to email us after this. Okay, so Farah has brought you through the COVID-19 Temporary Measures Act, which actually we've been advising on a lot because in these few months we've seen a lot of contractual disputes arising from parties' difficulties in paying the sums due under a contract, or difficulty in performing a contract. So that is one of the trends. The other trend, which I'm going to address, is that of investigations and fraud. So in some cases, disputes arise because parties cannot pay. In other cases, disputes arise because parties are trying to cheat other parties of money, unfortunately. And I'm going to talk a bit about the trends on fraud and what we can do to address these sorts of matters. So the impact of fraud on Singapore companies, PwC has been doing a global economic crime and fraud survey for a number of years. And every year they'll come up with a report to report on the trends, the number of companies that have experienced fraud. They also give their 2 cents worth on the reasons for fraud happening. And I think one significant thing in the trends is that the number of companies experiencing fraud has increased over the years. And certainly for me, so I've been in legal practice for 15 years. When I started, I handled a lot of commercial disputes, contractual disputes. But in the last 10 years or so, I've been doing a lot of investigations involving allegations of bribery, cheating, fraud, insider trading, market manipulation, etc. And part of it is probably because of the global financial crisis. So after the global financial crisis, there was a concerted effort by enforcement authorities to investigate cases and get back the money because everybody lost money. So that was in 2010. And generally, you see the US Department of Justice, the UK Serious Fraud Office stepping up their efforts to investigate and enforce against cases of fraud. In Singapore also in 2015, the CAD increased its resources on investigations, and it was also announced that the CAD is the Commercial Affairs Department of the Singapore Police Force, and that's the department that looks into white-collar crime, so your fraud type of cases. So in 2015, the PM announced that they were going to increase their manpower, that they were going to collaborate with the Monetary Authority of Singapore to investigate white-collar crime. So there is that general trend of enforcement as well, which probably can explain why the numbers that we see are going up because there's more enforcement now. I think another reason, and this is in PwC's report, they cited 3 reasons. One reason is the increased enforcement. The second reason is because Singapore is a financial hub. Although Singapore ranks very highly in the Transparency Index, in that we are one of the least corrupt countries in the world, there are still risks presented because we are a business hub within Southeast Asia and in Asia Pacific. So there are money flows through Singapore for these transactions that some of them may be tainted by fraud. So that's one of the reasons Singapore companies might be subject to the risk of fraud. And now, so today there was an article about how Singapore is technically in recession because there's a 42% drop in our GDP. And with a recession, people or companies may resort to different methods to try and earn money, some of which are not entirely right. And I think one of the reasons given in PwC's report is that the less favorable economic environment might increase the pressure on companies to meet their KPIs and this may unfortunately push them to commit fraud. So these are some of the reasons that the number of cases, that might explain why the number of cases have increased. And what is significant is also the financial losses that result from these cases. Again, the survey shows that significant amounts are lost by companies. So while most of the cases see less than USD $1 million loss for the company, but there are cases where the losses are even where they exceed USD 50 million, which is very substantial. Just to give you a couple of examples, I'm sure you've read it in the papers, but there have been cases of fraud reported about how the Commercial Affairs Department is investigating transactions, like, for example, the one that is shown on the slide now involving the purchase of surgical masks and hand sanitizers. Unfortunately, you always have people who are opportunistic to try and make money from the situation. I'm actually dealing with one case like that now. So my client is an American company who tried to buy surgical masks from a Chinese company, because China is where there was a lot of it is manufactured. And the reason I'm involved is because there is a Singapore company involved. So they went through a Singapore company as an intermediary because of the trade challenges and tension between China and America. And so it was two back-to-back contracts. Unfortunately, the Singapore company is stuck in between. The monies were paid, the masks never arrived. So we are in the process of investigating and seeing how we can help the company recover their funds if they cannot get the surgical masks. So again, this is another case, again involving masks, and the loss is almost 1 million Sing dollars. So we're looking at substantial amounts. Then we have phishing scams. I have been, on the receiving end of some of these emails, and I'm sure all of you have as well. There are people who try and get hold of your personal data by sending emails from email addresses that are masked to look like an official email address, but through these approaches they will get your personal details and potentially perpetuate fraud on the company or the individual. So fraud can be committed by both third parties that your company deals with, as well as employees within the company. I've dealt with cases involving clients who are cheated by third parties. Some of them also involve the employees working with these third parties to commit fraud against the company. So with that in mind, I'd like to turn to a different focus, which is what companies need to do to deal with these issues. And here I will talk about 3 broad points. 1 is on due diligence on third parties. 2 is on developing a compliance program within the company to make sure that employees are trained about what is right and that they are disincentivized from engaging in any misconduct. And 3rd is, if all these preventive measures don't work and you really have an issue on your hands, what you should do to address it. So due diligence on third parties, this, with the benefit of hindsight, is very obvious to a lot of people. Right now, the economy is not doing well, and in some of the disputes that we are helping clients on, unfortunately, the party that they're seeking to sue doesn't have money. So as much as you might have a very strong claim on your hands, if you're not able to enforce it against the other party because it's a $2 company, for example, then the judgment will be a paper judgment, right? And oftentimes in cases like these, the client will always say, oh, why didn't I do due diligence on the other party before entering into the contract? I would have known that they are only worth $2. The funds are overseas and not in Singapore, and so it would be difficult to get to. These sorts of information can be obtained even before you sign the contract with the counterparty. And I think now, with the economy being in the state that it is, all the more it's important for you to do due diligence before you enter into contracts. So there are the obvious way to do it, and in Singapore, we're quite fortunate because we have public databases that are easy to access, and it's relatively cheap to get corporate information on companies that are registered in Singapore. So you can go to ACRA, get information on the company and their financial statements. You should do a corporate insolvency search to just check that there haven't been winding up proceedings filed against the company. And sometimes it's not just about the company that you're contracting with. You may also want to look into the shareholders behind those companies or the individuals that are purporting to hold themselves out as authorized representative of the company. Where it may become a bit challenging would probably be in relation to overseas entities. If you're dealing with overseas business partners, you would have to explore public databases that may be available in those countries. And we often help clients approach law firms in other countries like Indonesia, Malaysia, to see if we can do similar searches there to get the information. And then in the more risky situations, like if you know that you're dealing in a high-risk jurisdiction and in a high-risk industry, then you might want to take the additional step of doing background checks on the counterparty before you even sign the contract with them. For some of the more sophisticated companies, they may even hire a due diligence company to do that for them. Otherwise, you can do some due diligence on your own by checking on their public presence, the internet presence, speaking to the counterparty directly. This is a challenge, maybe now not so much because we are out of the circuit breaker, but during the circuit breaker months when people couldn't meet face to face, there was the issue of how you're going to verify the identity of the other person. Those of you working in banks would know about the AML checks that are required, and you need to verify the identity of the person who comes to your bank. And where we are trying to social distance, and some people may hesitate to do face-to-face meetings, this might be compromised. So you just have to be aware that you need to know who you're dealing with. Turning to compliance programs, and this is where you deal with your employees and bring them up to a level to that they wouldn't commit any misconduct against the company. And here there are many issues to be addressed in terms of conduct. I mean, there are a lot of potential crimes out there, potential misconduct. I'm just going to highlight a few based on my experience on the types of compliance policies that I have assisted with. So in general, for a company, you should have a code of conduct. And you can see a lot of examples on the websites of, say, the publicly listed companies. They will have a code of conduct to talk about the values that they subscribe to, of honesty and general values that they will do the right thing. And then you should have a policy, or rather, there has to at least be guidelines to address potential issues of conflicts of interest. And this is where an employee may set up his own business, and things get complicated when there are contracts entered into between the company and another company in which their employee has an interest. Is not prohibited by law, but where conflicts of interest may arise, the key is there has always to be disclosure. And if the company knows about it, if there is approval and there is no under the table money or anything, then certain situations are okay. But there should be a policy to address the potential risks that are presented by conflicts of interest. Some companies have very strict guidelines that employees are not to set up their own company that has a competing business with the company, for example, or that employees cannot seek to refer contracts to relatives because that's a conflict of interest. Then anti-bribery and anti-money laundering, that is receiving a lot of attention now because of the global trends as well. Antitrust and competition laws. This is also one of the areas that a lot of companies look into, because, you know, especially for companies who have a sales function, there are risks associated with price fixing, bid rigging. So a lot of companies would have guidelines to tell their employees how to behave when they deal with competitors, you know, to make sure that they do not fall foul of the Competition Act and engage in any anti-competitive activity. Data privacy and security. So for Singapore, back in 2013, we had the Personal Data Protection Act, which is now going through some amendments. So that is a huge area of compliance that companies have to look at to make sure that all the protocols are in place and there is no inadvertent breach by the employees that may expose the company to sanctions by the Personal Data Protection Commission. And then last but not least, there are other regulations that companies may be subject to depending on the industry that they are in. So for the banks, you know, MAS has a lot of regulations that need to be complied with. Pharmaceutical companies would also be regulated. And depending on which industry you're in, you need to be well versed in the regulations and have policies that tell your employees what to do so that they will not get on the wrong side of the law. You know, this is just a helicopter view of the issues. I think each of these topics can be a session on its own, but I will not bore you with too many details. If you are interested in any of these topics, please feel free to reach out, and I'll be happy to speak with you. So when we talk about a compliance program, what exactly is it that needs to be done? And I think for companies, they tend to be focused on the operational aspects of this, you know, exactly what do I need to do to get my employees up to speed. Based on the guidelines that have been issued by the various authorities, so the US DOJ has guidelines. In Singapore, we have the Corrupt Practices Investigation Bureau talking about anti-bribery compliance program guidelines. There is also the ISO 37001 on anti-bribery management systems that talk about the elements of a compliance program. A lot of those that I've mentioned is on anti-bribery, but that's because it's a very hot topic at the moment. But if I were to speak generally about compliance programs, I think there are 5 elements. The first is leadership, and leadership really means tone from the top. And the reason this is always emphasized is because, you know, you can have all the nice policies that are drafted by people in the compliance function, but if you have a boss that does not believe in doing the right thing and sends the wrong message to staff members, then your compliance program will just fall flat. Risk assessment is the second element. And risk assessment is important because this is the part where you ensure that your compliance program meets the risk profile of your company. So for larger companies that are exposed to different countries and different industries, they would naturally have a bigger risk profile. For a smaller company, you might decide that, oh, your risk profile is low, and therefore you don't need so much in terms of policies and processes and the controls that you put in place. Then third is your policies and processes. This is where you come up with the guidelines that you distribute to your employees, telling them what to do and what not to do. Then training and communication is the sessions that you hold with the employees to make sure that they know about these guidelines and that they understand what is required of them. And then the last part of it is monitoring, auditing, and responding if there are any incidents of breach of the policies and the processes that you have come up with. So these are the overall elements. I think when we think about execution, we have to go into a lot more detail. And again, I'm happy to speak to any of you if you have any questions on the various parts of this. Okay, moving on to investigations. So I think if you prioritize due diligence and you prioritize a compliance program, you will help address the risks of fraud happening to your company. But but there is still a risk, and if something really does happen, what do you do? Again, turning to PwC's fraud survey, they have polled companies on how they respond to incidents of fraud in general. And you will see from the bar chart that most of them, they conduct an investigation. And I think this is the natural response. If an issue is raised to management, straight away they'll conduct an investigation. For some, they will disclose the fraud to a regulator, which may be the regulator that is relevant for their industry. So for banks, they might disclose it to MAS. If you were to report a case of fraud or any type of white-collar crime, you would report to the CAD, the Commercial Affairs Department of the Police Force. For some of them, they disclose to auditor, and for some of them, they hire external counsel. And I think for the last category, often it's the most serious cases of fraud with a lot of exposure on potential fines for the company, or even potential custodial sentence for the management of the company. But the one thing I would observe from this is that, even though the bar for indicative of the number of companies that conduct investigations seems to be quite high, but if you look at it, it's only 51% of companies that conduct an investigation when they discover fraud. So there's still 49%, almost half of companies don't do anything about it. And I don't know why this is the case. I mean, if I were to speculate, one reason could be because they are more focused on the business aspects, and these incidents, if they can write off as a bad debt, even if the company loses money, maybe some companies will take that approach. But here, I just want to point out some of the benefits of actually conducting an investigation, and our recommendation is always to look into the issues as much as it's extra work for everyone. And there are a few benefits. First, it allows you to find out the cause of the fraud, and this will in turn assist the company to put in place safeguards to address the root cause, as well as to prevent future fraud incidents from happening. If you find out the cause and you realize that it's a systemic failure, for example, your financial controls are not sufficient enough to detect a certain kind of fraud. It could be something as simple as, say, authority to issue checks. If the current protocol is that checks can be issued just by one person, then that in itself is a risk. And it's a risk that can be addressed if you have a check and balance in place where more levels of approvals are needed, and more than one person is required to sign off if the company were to issue a check of a significant amount. Of course, this is really simplifying the issue, but doing an investigation will help you identify the loopholes in the protocols and the procedures that you have within the company. I won't go too much into the investigatory process, perhaps just briefly on each of the steps, and this is in the interest of time, but if you have any questions, please feel free to raise it later on when we start Q&A. So in terms of the overall process, it always starts with detection. And then the question that we sometimes get from companies who approach us is, what do we do? And our recommendation would always be to do a preliminary assessment to see if there is any merit in the complaint at all. And if there is, start to scope out your investigation, take some immediate steps to preserve the evidence. Then you conduct your investigation and make whatever findings you need to make, and you decide on a response after that. So just going through each of these briefly. in terms of detecting fraud, a lot of cases, I mean, there are various means by which companies get notification of fraud that is committed on the company or by the employees. It could be through whistleblowing channels, through customers, in the course of management review, data analytics, through internal and external audit, or sometimes they have in place internal controls that pick up the fraud. So you just have to be mindful that, you know, all these avenues are avenues through which the issues can come, and the appropriate person should be tasked to address these issues. Then when you know about it, not all complaints would be valid. You know, sometimes you might have an ex-employee who has an axe to grind, you know, that raises certain issues with the company. You know, usually with that, I think anybody would be a little bit skeptical if the employee left on a bad note. You don't know if the report is credible. The first thing to do is always to assess the credibility and consider the potential legal issues before you jump in to do an investigation. And you know, there could be certain cases where an investigation is not warranted at all because the initial complaint is not justified or is not supported by any of the evidence that you have. If, however, there is some merit to the complaint, then you will need to define the scope of the investigation in terms of what are the facts that you need to look into, which of the business divisions it involves, what areas of law and which countries did the conduct occur in. There are small cases and there are big cases. For the bigger ones, you know, you may have to consider things like who should be in the investigation team if you need more than one person, and who are the decision makers. And if there is a potential need to report to law enforcement authorities, then you have to consider what the law enforcement authorities will require in terms of the scope of investigations. You know, this actually is very relevant from a US point of view, which I don't propose to go into here, but I can share more if any of you are interested. Then the immediate steps to be taken would be to secure the evidence and consider measures that may be required, such as suspending the employees, suspending payments or cancelling the contracts in question. For example, if you think that a contract is tainted by bribery, then the question is, do you still want to continue perform the contract or do you suspend it? Is there a need to notify the insurers of certain risk exposures if you are likely to make a claim? In certain instances, you might want to notify law enforcement and file a police report at the earliest opportunity. And then for cases that you think might be covered in the newspapers, then there has to be some consideration of, you know, what the company is going to do in terms of communications and PR, you know, whether you need to release any press statement on the company's position on the issues. Okay, then you conduct the main investigation. And I see it as two main parts. One is reviewing all the documentary evidence that you have, and two, interviewing the people that are involved in the alleged conduct, or, you know, people who might know about the particular transaction that is being investigated. And here it's a fact-finding process. The approach varies from case to case. In some cases, companies may choose to speak to key individuals first to get hold of the documents and then review the documents and identify further people that are in a position to give information. But you know, the thing to remember is this is really a fact-finding process. So when we are asked to help clients with these investigations, we work very closely with them to understand the structure of the company, where the information is, and what the best way to conduct the investigation will be given their circumstances. After finding the facts and and coming to our view on what laws might have been breached, by whom, and what kind of action we can take on behalf of the company, then we have to think about the response. Generally for us, we will always produce an investigation report. It may be oral or written depending on how big the matter is, and the authorities to which the company needs to account. And then we would advise on the appropriate remedial action. In some cases, the company may want to terminate the employee's contract because the employee is found to have breached the compliance policies of the company. In other cases, they may suspend, they may not terminate the employee, but they may put the employee through a certain compliance program for more training to make sure that a similar incident does not happen again. And then, of course, if the findings show that there is some inadequacies in the compliance policies that have been developed by the company, or maybe the company doesn't have any compliance policies at all, then the company would often look into having these policies in place to prevent a recurrence of the same incident. Other steps may involve reviewing third-party relationships. If it is a contract with a particular third party that has been tainted by bribery, then naturally you might want to review all the contracts that you have signed with that particular third party. And accounting adjustments may need to be made in terms of the financial controls that the company has. Disclosure to regulators may lead to other issues, because sometimes when you report a matter to the CAD in its own investigations may discover other facts that trigger a suspicion of other offenses being committed. And if the police chooses to investigate that, then the company will be obliged to cooperate with the police if they need to interview anybody from the company to find out more. So in a nutshell, that is what is involved in an investigation. Some companies are more sophisticated than others, and some companies actually have professional investigators. Some of you might have heard of the Association of Certified Fraud Investigators, which is an accreditation given for people who have gone through the training of fraud investigations. But then, for us, we are here to help companies if they have issues, if they need just general advice, we can provide that. And in the more serious cases where they need us to step in to help with the investigations, we do that as well. So with that, I will conclude my presentation, and perhaps we can go on to the questions section of this webinar. Thank you.
Thank you very much, Weiyi. Thank you very much. It was very, very interesting. I just want to share something really quickly. I came across, I live overseas in some periods of my life. I came across one case where it's a control fraud situation where, the organization was actually, having an issue with the CEO. And what happens is they need authority metrics in order to approve a certain payment of a certain amount of money. They need 2 people to sign off on that. So what happens is on the top of the authority matrix, there was a CEO, the CFO, and also the general counsel. So it was quite interesting because things were done to bypass the CFO. So it was interesting in a sense because when that came to light, the company took the steps of actually getting rid of the CEO instead of actually making it public or going through an investigation such as this. Control fraud is something which is, I'm not sure, but is this something that you have come across in your, what do you call that, in your law firm?
Yes, definitely. I think controls is a very big part of it. And particularly in the smaller organizations, power tends to be with just 1 or 2 people. And I'm dealing with a case right now where it's the ex-CEO of the company that is accused or suspected to have entered into transactions that compromise the interests of the company. So they enter into some financing agreements, and the financing that was meant to come through did not come through, and unfortunately the CEO has now been terminated. The company is trying to look into how it can claw back some of the monies that they have advanced in these transactions. And that wouldn't have happened if there was a control in place, right? To make sure that the one person does not have the sole power to enter into these contracts with third parties without accounting to the rest of management.
It's very interesting. There's a couple, quite a number. Hang on a minute. There's 1, 2, 3 questions that that have been posted here. I'll just go according to the sequence in which they were asked. I think this one might be to Farah. Okay, this is can notification for relief be done via email?
I think we addressed this question at the start of the presentation.
Yeah, we addressed this already, but I'll just, in case it wasn't caught, you can go to the Ministry of Law website to do the notification.
Okay, cool, straightforward. Okay, this is another question. Okay, my client is unable to fulfill a grant condition which requires him to place his staff overseas. Does ESG, Enterprise Singapore, has the right to cancel the grant offer?
This one really depends on the terms of your grant. So it's not possible for me to say just off the cuff. Certainly a grant contract doesn't seem to be something that would be covered by the temporary measures provisions that we discussed today. So the answer to your question is, it depends on the terms of your contract. You just have to read through and see whether this situation is covered.
This is actually quite an interesting case because I'm fairly familiar with this. So can we take our own government to task with regards to a failure of unable to meet a contractual term because they sort of offered the grant and the client then executed a series of contracts based on the promise of the grant, then later potentially may rescind the grant itself. So, and then the client is sort of out of the situation, right? Because he's already spent money, he's already committed to processes already.
Yeah, so I mean, first of all, I would say that the government is subject to the Temporary Measures Act, right? But as you can appreciate, this act does not cover everything, right? It's not a one-size-fits-all, unfortunately. It doesn't cover all the types of contracts, and I think it's unlikely to cover this kind of situation. So then the question is, number one, is there any state immunity for the specific kind of contract that is involved? And number two, what do the exact terms of the grant say? So a bit hard for me to say, just outright whether they can be taken to task. Of course, it's very unfortunate that the clients have lost money as a result, and they've made commitments as a result of the grant. But yes, it would really depend on the terms of the grant. And I think this sounds like the kind of thing where you have to get specific legal advice for each situation.
Right.
It's a bit more complicated.
Yeah, I mean, you think twice about actually wanting to bring your own government to on this, right? It's
yeah, I would say so.
Yeah.
And in any case, it's like I said, it's unprecedented. If they can't fulfill the conditions, but we're really all in this situation together. A lot of us have been pushed into situations that we just don't want to be in. So I think it's really a time for, to some extent, in the right circumstances, understanding and open negotiation if it's suitable.
True. Thank you for that answer. Okay, I've got another one here. Okay, will you get someone, okay, in case, there is a something to do with fraud, right? Would you get someone external to conduct the investigation, or will it be done internally? What are the check and balances assured to the public? I'm assuming this is a public company when it's done internally.
Yeah. So I think in your question, there is an answer suggested already. I think for me, it depends on the particular case. But if there is an exposure to the public, and it could be exposure in one of two ways. It could be because you have disclosure obligations to the regulator, and so you need to file a report with the regulatory authority, or it's likely to come out in the press, or if you're a public company and you have to make certain filings. If there is an exposure of that nature, then I think external help is good because they are neutral, and the whole process will be documented. For us as a law firm, the added advantage is that of privilege. So, you know, when you talk to lawyers, all communications are privileged in that it cannot be disclosed in court subsequently. So all the documents that we create in the course of advising you on your rights and obligations, which you may not necessarily want to share with the regulator ultimately, that will be privileged if we run the investigation. So I mean, when I do an investigation and I interview the employees of a company, I will always say, you know, we are engaged by the company to do this investigation. All the communications between the company and us are privileged. And so with that, I try and encourage them to be more candid in sharing information. And that will give you a better chance at finding out the truth ultimately, you know, because with investigations, sometimes people hide certain things they're not very comfortable with sharing. So if you have a law firm assist you with the investigations, advantage is that it will be cloaked with privilege. And so if there is a risk of disclosure to the regulators or even subsequent litigation, let's say after the investigation, you intend to sue a third party who has cheated you on the transaction, then that investigative material that you generated during the investigations will not come out in court unless you want to. I mean, of course, privilege is something that you can waive. So if you want to show it in court, you can, but if not, you don't have to. But there have also been cases where it's a relatively small matter and it's an internal issue. And I think when it comes to resourcing, we need to be sensible about it. If it doesn't justify the cost of getting a law firm on board, then the clients would sometimes do the investigations in-house, and then they will give us their report on the facts that they have found, and we will advise on the legal consequences based on those facts. So assuming that, you know, the person A did this, which is something that the company figured out on its own, then we just do the legal advice on your potential exposure to sanctions, for example.
Cool. Okay, there's another question here. It says, in the case of your investigation, in the course of your investigation, do you engage experts in forensics, particularly in issue related to AML, PDPA compliance breach?
Yeah, so we do. And I often work with the Big Four, KPMG, Deloitte, EY, the forensic teams, particularly on accounting issues, because when it comes to white-collar crime and money, the accounts always have to be scrutinized, because if you bribe someone, you will try and mask it as a different entry, you know. So it's always the accountants that will churn the figures and find out where the loopholes are. So I often work with forensic accountants on those issues. Yeah.
Okay, it's always like follow the money.
Yes, yes.
Discover what's been done. Okay, that's quite. Let me see. These are the questions which people have asked, and I think that we are almost at that time where we can go into our breakout rooms. Thank you very much, Weiyi, and thank you very much, Farah, because your sharing is really, really good, you know, and it's really, really interesting. So I encourage everyone, okay, a couple of things, right? Number one, okay, sign up for the WhatsApp chat group. Okay, please sign up. Okay, be in the know, be informed, and you know, be updated on what's going on. And number two, when we go into these breakout rooms, that's where it gives us an opportunity to connect on a closer level. And yeah, Weiyi and also Farah will be in one of the breakout rooms as well. So if there's any further question, you can ask in the smaller group chatting. So as we break out into a couple of rooms for us to really connect again, I want to thank you all, for taking this time to attend this webinar, and special thanks to Weiyi and Farrell, for really inspiring us, okay, about what's going on in organizations and what to look out for. And yeah, we will break out into the breakout rooms, and thank you very much again for your time here. We'll see you in the breakout rooms.
Thank you.
Thank you.